Swayam Prabha. Digital India. Educated India.
A very warm welcome in the fourth module of week 6 of the course Roadmap for Patent Creation, titled Statutory Differences between India, Europe and USA. Before starting that, going into the details of the differences, we will just see the brief about the patent system in these different countries, that is India, USA and the European Union as such. If you see USA scenario, the first patent statute, it was enacted. The object of that was that an act to promote the progress of useful arts. There were only 7 sections and the patent term at that time was 14 years. The patentable subject matter considered was any manufacture, engine, machine or device, or any improvement there is in a not before known or used. It was considered for the patent. After US became a signatory to the Paris Convention, it enacted Sherman Act of 1890 and the Evarts Act of 1891. This Sherman Antitrust Act was the first federal act and it was approved on 2nd July 1890. Now, the Sherman Antitrust Act of 1890, it was the first measure passed by US Congress to prohibit trust. In 1952, the new structure of Patent Act took place. Now at present, when we go and see the details of the Patent Act of USA, it is Title 35 of United States Code. So Title 35 of United States Code deal with the what we can say the all things about the patent. So this is about the USA. What about EU, that is European Union? In UK, two different systems coexist. One is the regional level and the other is at a national level. This EPC system works at a regional level and it covers 38 European states including United Kingdom. So when we think about a European Union, it includes total 38 countries. So whenever we are applying patent, we are applying in European Patent Office, that is this is a union of 38 states in Europe, right? Now it is an intergovernmental organization and it was set up in October 1977. Okay, now this EPC has two bodies. One is a executive level and other is a administrative. So we can say that title for that two bodies is European Patent Office Executive and European Patent Organization Administrative. Now it provides a uniform filing procedure to an inventor seeking patent protection in 38 European countries. So it's just like in Africa also there is a ARIPO. So similarly here in Europe it is a European Union and there you are applying the patent, and then after that you can just think about which country out of that 38 you want a protection, and then you can proceed for the taking that protection in that particular country depending on the market again. Okay. So UK is also a national legislation for grant of patent and it is also a part of obviously a European Union. Now moving further, when we see, we have seen USA, we have seen Europe. In Europe it is a European Union, in USA now it is a what we can say the 35, Title 35 is taking care of patent. What about India? We have already seen details about a Indian patent system, but to give you a little bit idea how that Indian patent system evolved, history is back 150 years. Earlier India followed British Patent Act, where it was British were ruling and we were following that British Patent Act. It was applied with subsequent amendments And then you can see, if you see this history now, just see this history here, and you can see that how it has evolved. In 1856, it was based on British patent law. Then it was further evolved. It was in 1883 as a Protection of Inventions Act. In 1888, it was like the Inventions and Designs Act. Then in 1911, the title was like a Indian Patent and Design Act 1911. Okay. Now, after independence, it introduced a bill in the parliament in the year 1965, and it was passed, and the act whatever we are following now, it is a Indian Patents Act 1970. Now, there were few amendments after that, that is from after 1970. It was in 1999 the first amendment, after that happened, that after that 1970. In 1995, India became a signatory to the TRIPS, right. What is the TRIPS? TRIPS is a trade related aspects of intellectual property rights. Now, once you become a signatory, you have to follow the whatever the guidelines are given by the TRIPS. So, it became obligatory for India to include the provisions of the TRIPS, right. And therefore, the act, that is Indian Patents Act 1970, it was amended in 2002 and then in 2005 subsequently to fulfill the TRIPS obligations. The timeline is given, considering our developing countries, a timeline up to 2005 is given, and accordingly India then amended, and first amendment done in 2002, second amendment done in 2005, then mailbox provision and all that facilities were available at that time. Now, nothing like that is available, everything is now included according to TRIPS guidelines, and new amended act is followed. Okay, so this is what the India patent timeline, how it is evolved. So, now after seeing this three countries like India, USA and this European Union having that 38 countries, now we will see the what are the statutory differences among these different countries. Now, although first to file versus first to invent, this rule is now completely what we can say, it is not followed now anywhere in the world, but just to give you idea that US used to follow this system, that is a first to invent, and we have seen that because of that only that the restriction endonuclease enzyme could receive the patent, otherwise it was not possible to receive patent. First to invent over a first to file is the what we can say the rule. US used to follow that first to invent, and other means any other countries in the world, they used to follow from that first, like there were no rule like a first to invent in any other country. So, it is always a first to file. Okay. Now, in March 2013, with the America's Invents Act, that first to file rule is now accepted, and now that only first to file rule is there, no first to invent rule is followed. So, this is about the first to file and first to invent. Next is a grace period for disclosure of a application. Now, as there was a first to file, that first to invent rule was there, that 1 year grace period has given to the inventor to give the details about that whatever the invention, that they have to prove that that 1 year gap it is allowed. So, your invention should be before whatever you have filed. Suppose you have done the invention today and you have filed patent, you have published that thing and you have filed patent later. So, that after that publication 1 year timeline is given, but now such timeline is not available, that grace period is what we can say not available. But there is a one minor thing is there in USA, that is if inventor publishes that particular thing, particular invention, if he makes it public, he can get the chance to prove that okay, he has invented that thing and he can get that grace period. But nowhere in the world now you can say that this kind of grace period is there. Compulsory first to file is important. Now, we will move further and check now the next one, that is what are the types of patent, right. Now, you can see that whenever you consider Europe, India and USA, In Europe and India, there are only two types of patent. What are these? Product patent and a process patent. Whereas in USA, there are three types of patent, that is utility patent, design patent and a plant patent, right? Now, utility patent granted to anyone who invents any new or useful process, machine, article of manufacture or composition of matter or any new or useful improvement thereof. That was a utility patent. What is a design patent? It is granted to anyone who invents a new, original and ornamental design for an article of manufacture. It only protects the appearance but not the functional or the structural features. And the protection for design patent, nowadays it is a 15 years, it was before only 14 years. It is now 15 years. Now, if you see most of the jewelry, right, what we can say the placement of diamonds to create some specific design, all this will be patented in USA under a design patent. And you can see many Indian, what we can say inventors who are patenting design patent in USA, right. Now, plant patent, it is granted to anyone who invents or discovers or reproduces any distinct, any new variety of a plant, including a cultivated, what we can say the mutants, hybrids, seedings other than a tuber propagated plant. So, you can see the difference, that is in USA you can have a three types of patent: plant patent, design patent and utility patent. In India and Europe you will find only two categories, that is a product patent and a process patent. Okay. So, this is a difference considering the types of patent. Moving further, test of obviousness. Now, there are different approaches followed. There is the statutory requirement for obviousness or inventive step is same in all jurisdiction, that is in India, Europe and USA, right. Now, difference lies in the method of interpretation that has developed through the court, right. That is the only difference you can see. Now, in India, the test for non-obviousness, if you see, it is interpreted by the Supreme Court in a Vishwanath Prasad Sham versus Hindustan Metal Industries. Now, if you see this case, according to this, the test, that is a inventive step, it was decided that what has to be determined is whether at the time the invention was made, any other person skilled in the same field would have come up with the same invention had he faced the same problem. If the objective answer to this question is yes, then only invention is obvious. Okay. So, you can say that this Supreme Court case in India, Vishwanath Prasad versus Hindustan Metal, it determined the test of inventive step. In USA, if you see, the provision for non-obviousness was interpreted by the US Supreme Court in the court that the case which was the Graham versus John Derrim. Now, here they have given the guidelines. What that guidelines are there? That determine the scope and content of the prior art. What is that scope given by the prior art? Analyze the difference between prior art and the invention. Then determine the level of a ordinary skill in the pertinent art. Ascertain secondary considerations of non-obviousness, that is long felt need but unmet need of a device or the failure of others. So, this was the case, this was the scenario in USA. What about European Union? In European Union, the Board of Appeals at the European Patent Office have interpreted the meaning of non-obviousness or inventive step, and the approach which is taken in European what we can say Union is a test of problem solution. Okay, that is the approach. First, what the steps they have to follow here, that first choose the closest prior art, right. Then they determine the technical problem, that invention addresses, determine the technical differences between the closest prior art and the invention in question. And the next step is examine a solution. whether the solution is obvious to person skilled in a art. In this way, you can say that in India, that Vishwa Prasad case, then in Europe, there is like a guidelines, that is a problem solution approach, and in USA, Graham versus John Derry, that case, that have determined the test of inventive step. Now, moving further, if you see how the best mode of requirement is considered in these three countries. In USA, obviously we have seen that Title 35 is now dealing with the patent. Now, here the patent law requires the inventor to disclose the best way to practice the invention in a patent application. Failure to do that, it can invalidate the patent application. Under the America's Invents Act, now it is formally required by the applicant to disclose the best mode, but without invalidating the patent application. In India, it requires an applicant to disclose the best method of performing of the invention which is known to the applicant. The applicant also required to disclose all the best mode of performing of the invention if there is more than one in the specification. In Europe, you can see that there is no such requirement. Only one way to perform the invention must be included into the application. Okay? So, this is what the European. Now, moving further, next, that is a non-patentable invention. In European Union and in India, what we can say, in European Union there is a Article 52 and 53. These are giving details about a non-patentable inventions. And already about India, we have seen that Section 3, which is giving the list of what we can say the inventions which are not patentable. And obviously, we have also seen Section 4, right. So, in Europe there are specific article, in Europe there is an article, in India there is a Section 3 and 4, and they are determining that which are the inventions which are not patentable. Now, the two countries follow an exclusionary approach as to what is mentioned under the statutory list cannot be patented, while that which is not mentioned under the list. Okay. In US, the statute describes what is an invention and can be patented. Unlike European Union and Indian approach, it will not express what is excluded. No? So, it is not expressly excluding anything. US follows an inclusionary approach as to what is mentioned in the statutory list. It can be patented and not otherwise, right. So, this is the US approaches. So, US approach is little bit different. European approach and Indian approach, these are almost what we can say overlapping. Now, moving further, you can see the what are the rights conferred by a granted patent. An Indian and US patent is a property right that is enforceable the whole territory of India or USA respectively. It allows the patent holder to prevent anyone from making, using or selling the patented invention in the respective countries, right. So, when we have seen the definition of patent, we have seen that what rights are conferred by the sovereign when the patent is granted, right. So, it is considered as a property and these rights are confirmed. And European Union patent on the other hand is when it is granting that patent, it is a regional treaty. Already we have seen that it is a regional treaty, and the grant of patent under that European Union, that European Patent Convention, it confers upon the owner the option now to choose the countries in which he or she want to protect from the list of 38 countries. We know that 38 countries are the members of that European Patent Convention. So, once patent is granted in European Patent Convention, next step is like you have to choose the country where you want to get the protection. Now, the patent holder then have the right obligations as mentioned in the national patent law in those European Patent Convention countries, right. So, according to that, the things will be governed. So, you can see that this minor difference, because in European what we can say Europe, there are 38 countries and there is a one single contact or single point is there. Once it is granted, then you can just move further and you can just opt the protection in any of the country that is out of that 38. In India and USA, you are directly getting that rights in that particular territory. So, this is what the difference considering the rights conferred by a patent granted. Next, publication of a patent application. If you see USA, until 2000 the patents were published only after they were granted. That was the scenario. But after amendment in 2000, everywhere it is followed, like after 18 months the patent will be published, right? And this rule is followed everywhere. So you can see in USA or in Europe or in India, the patent publication will be at the end of 18 months, unless until if anybody have not given the request for withdrawal. That is one thing. And second thing is that if somebody have given the used expressway, then before 18 months the publication will be done. In India that facility is available. Okay. So in this way the only difference is that a non-publication request can be made in USA, while it cannot be made in a European Union and India. So this is what about the publication. Now next, moving further, challenging the validity of patent. We have seen that in India there are post grant opposition and pre grant opposition. What is the condition in US and European Union? In European Union within 9 months and in India within 1 year, right? You have to file the, what we can say, the anyone can file an opposition with the patent officer, giving the evidences and the reason, grounds for the what that opposition, right? The officer can then conduct a hearing where both the sides are allowed to argue and then defend the case. This is known as a opposition proceeding. In US there is a re-examination proceeding, that is a difference. Okay. So here in the re-examination proceedings, it can be initiated by anybody during the life of patent with a USPTO examiner by presenting reasons and evidences. In any of the case, obviously you have to give the evidences and you have to give the reason here, right? So this is what the post or what you can say the opposition proceedings. Here USPTO examiner acts as an arbitrator and examines the patent on the grounds of obviously novelty, non-obviousness and utility. So this is what the USPTO case is. In India we have seen that option is like a pre-grant opposition and a post-grant opposition, and we have seen in detail any person can file opposition before grant, and after grant person who is skilled in the art only can file the opposition, and the timeline is 1 year. So this is about the opposition. Now the next is a patent term adjustment. The patent term in India and Europe is 20 years, and that is from the priority date, and there is no any what we can say the patent term adjustment facility is there. In USA you can say that the term of utility and plant patent is 20 years, design patent it is a 15 years. That difference is there, right? So this is what the utility patent, plant patent, these are eligible for a patent term adjustments. That facility is there, but you remember that utility patent it is and plant patent for 20 years and the design patent is for 15 years. Now for that there is a grounds given in USA. If they are giving the adjustment, what are the grounds are given for the extension? Failure of USPTO to take certain action within the time specified under Act. So if patent office, patent and trademark office fails to take necessary action, and if because of that the delay is there, then that can be considered. Then failure of USPTO to issue patent within 3 years. So timeline of 3 years is there. Within 3 years, if USPTO will not give the or issue patent, then it can be considered. And then the compensation for delays due to interference proceedings or secrecy orders or what we can say a successful appellate reviews, if that kind of scenario is there. So if that any of the 3 scenarios are there, term can be adjusted, but that facility is available only in USA, not in Europe, not in India. Next, moving further, you can see a language. In which language you can file a patent. In USA and in India, it is always a English language, it is compulsory, while in European Patent Office you can see the official language also includes along with English, German, French, and applicant is allowed to file a patent application in any of this official languages. So this is what the languages. Now, after going through these details, right, what is a language, a term of adjustment, what is the opposition procedure, how the terms, what is that, that term adjustment is there, right, all these things, whatever you have seen, the differences between India, Europe and what we can say the USA. Now, once you see these differences in between this Europe, USA and what we can say the India. Now we come to the almost we have seen what are the differences, and you can see the similarities between European Union and this India, right. Now you just take a few minutes and watch this video.
Over the last 2 decades,
with this, we come to the end of this session. In the next session, that is identification of inventor and applicant and their rights, we will learn about who is the owner of patent and what are the rights of both, that is inventor and applicant. See you in the next session. Thank you.